shoot, I should have turned this over way earlier.
Because, I mean, do you think that it's reasonable that at least by that point you should have shared that information with the defense?
You know, I'm sad saying that. I'm really hurt saying this, but this is not new. So.
Okay. At this stage, which is mid-trial, anything else, whether it's Brady or not, that you think might be relevant to either the state or the defense in trying this case that you, the state, know of that the defense still does not know of?
Wait a minute. Did the state and prosecution just get caught up again withholding evidence from the defense 107 days into the trial? And potential Brady evidence at that? Man, y'all stay tuned as we jump into the details, breaking down exactly what happened, how this could be a potential big impact on the YSL trial altogether.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep.
So as day 107 of the Young Thug YSL Rico trial kicked off, and another motions hearing during a recent court session, allegations surfaced that the prosecutor involved in the case was again caught hiding evidence or withholding evidence from the defense. Now, of course, it's normal the prosecutor actually states that it wasn't actually done on purpose, but ask yourself, have we not seen a pattern or a history of behavior? Now, this evidence was reportedly crucial for the defense, raising questions again about the integrity of the prosecution. But as Judge G said, proper preparation prevents poor performance. But ask yourself, is it fair that the state is actually being prepared and the defense doesn't have access to this information? Now, the evidence that is in question are the wiretaps that the state was actually going to utilize. Again, wiretaps that the state was going to actually utilize. Now, this is interesting because if it was a wiretap, that means that they've had this information for a while, because evidently it started internally before it made it external. But ask yourself, why is the defense not giving the fair play at this evidence that the state is planning on using to try to prove conspiracy? Now, when this information was discovered, the defense team did immediately bring it to the new judge's attention, and the judge's reaction was definitely quick and decisive, definitely questioning the integrity of the case as well as the state. Let's dig.
I don't assume that was served in discovery, was it?
I'll check. It should not have been, because the reason that the phone records weren't served was that they were considering arresting him.
So the answer is no on that one.
Correct.
Two things, Your Honor. First, yesterday we were told that it was, to my understanding, an inadvertent oversight by the state to hand over these records. Now we're being told it was a conscious decision not to hand over the records. Secondly, regarding the affidavit for the search warrant for Mr. Boyer's, presumably Mr. Boyer's phone records, I specifically requested that yesterday via email, and I haven't received it either.
Now, how many times have we actually heard that saying? Your Honor, we don't have the evidence. The state has yet to render the evidence. They haven't turned it over to us yet. The state has evidence that we haven't seen. It's nonstop. And the DA and prosecution, full of excuses. If the tables were turned and the shoe was on the other foot, you think they'll be this patient with the defense? Would a new judge stay this patient with the state? Or is this just a play? Let's dig.
Is there some reason that can't just be shared right here and now?
They're trying to thwart a murder.
They're trying to do what?
Thwart a murder that is underway or being.
Okay, then seems they should pass off the responsibility for getting the affidavit to someone else. Did you in any way respond to Mr. Schart?
No, I didn't see the affidavit email. What we were trying to get last night was the information about the phone records. That's where I got part of what I provided to the court this morning.
Okay, and so you didn't see the emailed request from Mr. Schart last night that said, could we please have the affidavit in support of the cell record?
I did not, and the court is welcome, Mr. Schart is welcome to look at my email.
I'm sure you get a lot of emails.
I did not see that. I don't even know what time he sent it, but I did not see it.
And I want to be very candid with the court. I sent this to Mr. Atkins because he was the one that sent the information.
Well, that's why you didn't see it in the slow, because it wasn't sent to you, it was sent to someone else.
Because he was the one that sent us the phone records. And I want to be clear, and I think it's clear what I wanted, but my email said that I wanted to see the search warrant, which we haven't received either. Obviously, I meant search warrant and affidavit, but I
Okay.
did put search warrant. But we haven't received either.
At what time did you send that? It was,
1:53 p.m.
so yesterday afternoon. Okay. Okay.
Crazy. Now, interesting, if this was actually true, then the DA and the prosecution team would definitely face some serious consequences. But luckily, YSL Schart jumped in and actually cleared the room and set the record straight. Look at the YSL defense team saving another client. Salute to the YSL defense team. Let's dig.
Okay. Okay, so I understand that you, well, let me, I can't remember who just stood up and raised it, but whomever said that yesterday you said it was inadvertent, and this morning you're saying there was a decision made not to share this information with the defense because Mr. Boyer had not yet been arrested and APD was contemplating whether to secure a warrant, and I didn't want to alert him. So which is it?
Thank you. They are both. I asked the court yesterday to allow me the time to speak with team members.
Right.
And information internally that I know is that when the phone records were initially secured,
In the fall of 2023.
yes,
Okay.
when they were initially secured, the thought process was, we're going to get this person arrested and indicted.
Okay.
As time went on, our team had the records, and as we advanced in trial,
Do you know when the decision, if there was one, was made, okay, we're not going to get a warrant for him after all?
I don't think that decision was ever made, because talking with the lead investigator who got the records last night, there is still frustration because they get permission to get the warrant, and their efforts have not yet been responded to. So they're waiting. That person wants a warrant. So there's not, the decision to obtain the warrant has not been abandoned.
Okay.
Efforts to obtain it have not been abandoned, but we are at a place where it occurred to team members that, oh wait, we have this, we need to give this over. And it wasn't time progressed and over to be quiet.
Okay. Because, I mean, do you think that it's reasonable that at least by that point you should have shared that information with the defense?
Great storyline, Ms. Love. We get it. You got a reason why, or excuse, a justification, a storyline. Great. At the end of all of that, guess what we learn? Nothing. Same thing we've been learning with this whole trial, this whole case, with your evidence that you're standing up here. And it's just interesting to sit up and watch this case just continue to crumble. Now, I like the judge. Some don't, some do. Her sense of humor maybe dry to some, dark to other, but it's transparent. And that's what we need in this case. This actual situation with this judge, the evidence that's being presented, is creating transparency. That's what we need, and transparency in the justice system, transparency with the integrity of this case. So far since it started, 107 days in, I haven't seen transparency. Even from the day one opening, things were not clear. And as of now, they're still not clear. Let's dig.
I think that when we're talking about realization and oversight, that at least at that point, if not sooner, at least at that point, that is when it was, oh shoot, I should have turned this over way earlier.
I'm sad saying it. I'm really hurt saying this, but this is not new. So a date when Miss Love just said, "Oh shoot," this is not a quote, but something effective. "Oh shoot, we must turn this over." That was before giving it to Agent Bernie. So what happened on that date of the "oh shoot" to we get it yesterday, and we don't get it? Oh, this is new stuff.
Good question.
So we are one team, but we have many members and parts. But I will get the date. But I can tell you that when I said that there was the realization that we do need to turn it over.
Yeah. When did that realization occur?
Who are these niggas?
I cried laughing when I
You know what I'm saying? like, we need to stay away from these niggas.
I will find out, because it was not mine. It was not my realization.
Okay,
So I'll find out. What I'm saying is,
Who's in charge of the team?
I am. And so that's mine, generally speaking. I'm saying that in terms of a date certain, there was communication internally. We looked at it. We were looking at everything we had to turn over, and we were looking at anything that we haven't turned over. Collectively, we realized, oh my goodness, this has not been done.
All right. And you don't know what date that happened?
No, that's what led to turning it over.
On Monday.
Yes, this weekend we were talking about it and we turned it over.
All right. So sometime over the weekend is when the realization occurred. Oh my gosh, you knew you hadn't turned it over. Oh my gosh, we need to turn this over.
Oh my gosh, it has not been turned over and we need to turn it over.
Okay. And you're getting us the information about when we get the affidavit in support of the search warrant for the cell records, we'll know the date that occurred.
That is correct.
Uh-huh.
We're working on that.
And it did not occur to anybody at that point in time that this is information to be shared with the defense.
When the court says at that point in time, you mean with the affidavit for the search warrant? When the search warrant for the records were obtained?
Yes. Right? I mean, obviously not, since you got them in the fall of 2023.
And because the information that the search warrant was based on had been provided. So, we weren't thinking along those lines then.
Okay. Had you at any point provided information that the phone number that y'all all know about is actually DeMarco Boyer? Did you ever before Monday share that information?
No.
Okay. All right. What was the nickname?
Unk is the name that's listed on, I think, in the wiretap. I think it's
Okay.
April 13, 2017.
13, 2017. All right. Thank you. Okay.
The remedy of exclusion, as the court is aware, is one that is extreme, and generally it would be appropriate when there has been some kind of harm and there has been some kind of bad faith. I'm not saying that that's the only time the court makes the decisions. Our argument would be that it should only be employed if there's something prejudice.
I understand. So how is it not bad faith? And I don't mean this personally, but how is it not bad faith when you've been ordered by a court, probably orally and in writing, that you need to produce things as they come into being and as you know about them, and then you don't do that?
So ask yourself, bad faith, great choice of words, or bad choice of words? In my personal opinion, I would say great choice of words. Most of the stuff that we've been saying and the handling of the evidence and the way that the state has just been moving all together definitely doesn't look like it's out of good faith. The only thing that was out of good faith were the actual state's witnesses that worked for the state that they called up to the stand. Other than that, the own state's witnesses have been impeached. That's not good faith. Withholding information, not good faith. Hidden ex partes, not good faith. Redacted transcripts, not good faith. Brady information, not good faith. But of course, leave it to the state. They got an excuse, a justification, and a reason why. Let's dig.
Bad faith would be holding it back for some kind of advantage, tactical advantage. And if we're saying we don't have to put that up until the last 5 witnesses, and we are at witness 80 in a list of 175, giving them the records or the plots now, literally when we have people,
Okay, so that sounds more like an argument that they aren't really prejudiced because they still have plenty of time to handle it, right?
It's actually for both, because what I was saying is, to say it's bad faith would mean that we held it back for, that's still not the only definition of bad faith, but we did not hold it back for any, we did not intentionally keep it from them.
Okay.
It's.
So how is it that it came out on Monday or occurred to y'all over the weekend and you produced it on Monday? Is it because because y'all finally got together and said, all right, y'all, what else is there that we ought to be giving them? Why 2 months later?
So
there are the details about what your intended trial evidence is going to be that finally made y'all get organized enough to realize, oh shoot, there are some things we have not shared yet. Fair?
It is the court's order that got us to do that.
Okay. All right. So that is probably not bad faith. That is it being swamped because there's a lot of evidence. And I am exercising patience despite the suggestion that I not do that. And I hear that you probably think enough patience has already been exercised. This needs to be the last of it. I mean, it's sort of like when somebody comes before me on a probation violation and it's the first time I'm seeing them. I don't know what they thought about getting away with anything before that. But once I talk to them, I expect them to abide by it. I expect you to abide by it. So between now and noon on Friday, you better make sure you have got all your ducks in a row and you have shared those ducks and ducklings with the defense.
Is as if it's a first argument to you because they know you haven't been here for 19 months. These arguments, I've heard them so many times, it's countless.
I understand.
Right. And for the state to argue it's not bad faith, I'll give you an example of things that we've been through before we had the opportunity for you to be presiding. Disclosure and timely disclosure. The state's been caught before. Specifically, I remember a late discovery disclosure that once it was disclosed, it actually had a comment on there that was supposed to be internal that said, do not serve yet. They did it on purpose. And how many times can you say, oops? How many times can you repeatedly, systematically make the same mistake as an experienced litigator and say, it's not bad faith? Okay. Your Honor, I'm just asking that the rules be enforced. Because if they're not really rules. They're just aspirational.
All right, I understand. And
So as you see, again, the state got caught up in its own mess with their hands in the cookie jar, holding evidence, changing evidence, and lying about evidence. So ask yourself, is this trial ever actually going to have the opportunity to be fair? Now, the public reaction has definitely been mixed. Some actually feel like this is a definite violation of legal ethics, while others are actually skeptical about the impact of the state's tactics altogether. Some say that it would not actually even impact the case. In my personal opinion, the case was impacted before it started. Now, the case involving the prosecutor holding the evidence and hiding evidence has definitely introduced another dramatic twist in the Young Thug YSL Rico trial, and it should actually raise a lot of questions about justice and accountability. Is anybody responsible for the state's action, or do they just get to move because they're the state? What you think about the case? Y'all share y'all's thoughts in the comments below. Don't forget to hit that like, share, comment, and subscribe. Definitely tap that notification bell so you'll get the updates whenever we drop on this channel as well. And as always, remember, the life you save might just be your very own. Y'all remember to stay safe, stay vigilant, and remember, it's your boy Jay. Gone.